So they partnered agreed on a matter of advanced warning technology for local industry accords and Uniserve Limited.
Yes, Mr. Lewis.
My Lord, good morning. Can I pick up where I left off yesterday on the point of delivery? This is ground one of appeal. Can we go straight into the judgment, please? Page 217, Paul Bundle, paragraph 292. We looked at this paragraph yesterday. And it's the last full sentence of 292. This is the judge's finding. Hitex's responsibility under the supply contract was limited to having the goods available for collection on or by the agreed dates, which should now be taken as those agreed in the revised schedule. I point that out because that finding is not challenged on this appeal. Indeed, in my submission, it's correct, but we actually don't need to go there. Uniserve's obligations are set out in 2.2 immediately above. And it's the second full sentence. Uniserve shall procure that such a duly authorised, in fact, let me back up. Delivery shall be completed when goods have been unloaded. And my Lord, you referenced yesterday why unloaded. These are standard terms and conditions. So they're providing, I think, maybe there's an occasion when goods will be unloaded at an airport or something like that. In this case, we know from the sale contract that all Hitex had to do was have goods available at the factory. And we see that at clause 4.
So we effectively ignore that?
Yes, for the purposes of this, because it's the requirements, the instructions from Uniserve, delivery X works at the factory. That's Hitex's obligation, and that's consistent with the judge's finding I've just taken you to. So delivery shall be completed wherein goods have been unloaded and such delivery has been received by a duly authorised agent, employee or location representative of Uniserve. Magellan was the location representative in this case. Uniserve shall procure that such a duly authorised agent, employee or location rep is at the factory at the agreed delivery date and times. So Uniserve was required to attend through its agent at the factory on the dates, but there were no specific times, but on the dates. The time of the essence provision that we discussed yesterday, I thought about this overnight, and that goes to remedy. It's not Hitex's case. By a non-collection, which I'm going to come on to, and term a rejection of various instalments of goods, that Hitex was entitled to treat the contract as at an end. It wasn't. It would have had to have made time of the essence in the usual way. But Hitex does have an action for breach of contract. And that's what I'm dealing with in the context of retendering. So it can sue in respect of missed deliveries, and I'm going to make that point good in due course.
How does clause 2.2 interrelate with section 37 of the Sale of Goods Act?
I don't have that section in front of me, my lord, I'm afraid.
Section 37 is the section that deals with buyer's liability for not taking delivery of goods.
My lord, I haven't got it in front of me. It wasn't a point developed below or in this appeal, and I'm afraid I'm not able to deal with it right at this moment.
And what it says is when the seller is ready and willing to deliver the goods and requests the buyer to take delivery, and the buyer does not within a reasonable time after such request take delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for care and custody of the goods. That's the statutory provision for when a buyer is liable for not taking delivery.
Well, my lord, it's a point I would need to think about carefully. As I say, it's not a point that was taken below by Uniserve. It wasn't a point that was argued. It's not a point that's been developed on this appeal. So forgive me for not having the answer.
But it's agreed that the Sale of Goods Act applies to this sale.
Yeah, well, Yes, the question is whether the specific terms of the contract, I suppose, override that
But
section.
you're claiming under Section 50,
Under Section 50, yes, indeed.
which means you've got to show non-acceptance.
Yes, I do.
And Section 37 is the provision that triggers that liability, doesn't it?
Well, if you've not looked at this, Mr. Lewis, then perhaps you better think about this question my lord is asking.
I certainly will, but as I say, it's not a question that's been, or a point that's been developed thus far. Not to say it doesn't need to be answered, but it's not one I can answer immediately without some investigation.
All right. Well, rather than try and force you to answer when you can't, please do think about that and come
Yes.
back to us.
I'm grateful. The next question is whether Hightex complied with its obligation, the obligation as found by the judge, and to what issue that goes. So the starting point is to examine the pleadings, but only very briefly. Beginning in Core Bundle 359, looking at the re-amended particulars of claim here, paragraph 23. Where Hightex pleaded that in breach of the supply contract, in particular the primary obligation in clause 5 of Schedule 2, save as a
Sorry,
force.
which paragraph you?
I'm looking at 23.
Right.
This is where Uniserve pleads that Hightex in breach of the. This is where Hightex pleads that Uniserve in breach of the supply contract has failed to receive and pay the goods. And the response to that paragraph is in the re-amended defence and counterclaim at page 379. Paragraph 12. Uniserve said, in the circumstances, paragraph 23 are denied, and the circumstances are those set out in paragraph 10 above and the subparagraphs. Paragraph 10.2 on page 377. Uniserve plead that to the best of its knowledge, the failure to meet the delivery schedule prescribed in the supply contract amounted to breaches of clause 5 and 11 and resulted from breaches of clause 7.6.1. 10.2a. On the claimant's own case by the 14th of June, that was the fourth delivery, Hightex had only delivered 5 million units. Consequently, it had not yet completed delivery of the 6 million units due on the 28th of April 2020, or started delivery of the 5 million units due on the 5th, 12th, 19th, 26th of May 2020, or the 7 million units due on each of the 2nd, 9th of June. But this is the variation point. Uniserve here are saying, we didn't vary the contract by the revised schedule, you're in accrued breach, and therefore we're entitled to terminate. So that's what that goes to, and that's ground 3. At 10.3, Uniserve plead that accordingly...
Well, 10.2a has, even if the supply contract was varied, then...
But that's the accrued right point. So Uniserve are pleading that even if the supply contract was varied, Uniserve are not prevented due to waiver. The supply contract was varied.
Hightex failed, they say, to make various...
Yes. Yes, on the 14th, 21st, 28th and 5th of July. This is all before retendering. Retendering starts on the 12th of July. So we looked at the tables yesterday. I think it was 396 of the judgment, where we saw that up until the 5th of July.
So when you say retendering started on
the 12th of July.
Can you just unpack what you mean by that?
Yes.
What happened? What do you say
Well,
retendering amounts to on the 12th of July?
Can I take you to, I'll just put a note there, can I take you to paragraph 396 of the judgment? You'll find the page reference. Page 235. We went through this table yesterday, and the agreed position appears to be that up to the 12th of July, once we take off the goods that had already been delivered, this is the judge's calculation in the paragraph below, Hightex had sufficient accumulated stock in the warehouse to meet each of the deliveries as they fell due.
Okay, that's what you meant by retendering.
Yes, as of the 12th, we accept that the required amount was 21 million, yet there was 18.4 million of accumulated stock. Therefore, if the retendering argument fails, in that Hightex was not entitled to use goods that had accumulated in respect of other shipments, Hightex didn't have sufficient accumulated stock by that date.
And it's the label you've attached. I mean, nothing actually happened, did it? Other than this is just a construct built off the back of the number of masks in the warehouse. I mean, it's not as if you suddenly started doing something.
Well, we had the masks available in the warehouse on the given dates.
It's just the concept of tendering.
Yes.
It's not as if you suddenly, you didn't, unless I've misunderstood, you didn't suddenly start offering or calling up and saying we want to deliver X masks or anything.
Correct.
It's just, that's your label for...
That's the label as to what happened.
Up to that point in time we had enough to fulfil, and you say thereafter we didn't unless we could
use stock already available.
Stock there and not accumulate the delivery requirements.
Yes.
So that's what you mean by retail.
It is.
In effect, you continue to have stock available to meet the next instalment, but not to meet any cumulative total.
Yes.
Yeah.
Exactly.
That's fine. Sorry.
If it's your case that if they don't come to collect on the 5th of July, they have not accepted, and at that point you've accrued a right to damages for non-acceptance.
Yes.
You can go out to the market and sell those goods
Yes.
in mitigation.
Yes.
Then on what basis are you then obliged to
That's exactly.
sell them later?
Well, the point is if we're obliged to mitigate, I'm going to come to this and I will in a minute, but if we're obliged to mitigate, it means we're released from supplying those goods to Uniserve. If we can sell them to Mr. X and buy them back, we could then supply them again to Uniserve.
But you can only do that if the contractual obligation to sell to Uniserve in relation to those goods has been brought to an end. You can't.
Well, unless it's treated, and we submit it should be, as a severable breach. And I took it to the extract in Benjamin that we saw in the judgment.
But you seem to be regarding two things. One is you seem to be regarding the total as cumulative, and secondly, even if it was severable, you'd have to accept the breach. That you'd have to accept the repudiation, which you don't say you did.
Well, in my submission, we wouldn't have to accept the repudiation, and it comes to the extract at 369 of the judgment, page 232. Benjamin 9-010, where there's a contract for sale of goods to be delivered by stated instalments which are to be separately paid for, and the seller makes defective deliveries in respect to one or more instalment, or the buyer neglects or refuses to take delivery of or pay for one or more instalments. It is a question in each case, depending on the terms of the contract and the circumstances of the case, whether the breach of contract is a repudiation of the whole contract, we don't say that it is, or whether it's a severable breach giving rise to a claim for compensation, but not a right to treat the whole contract as repudiated.
But you have, absolutely, whether it's the whole contract, but you certainly would have to bring to an end the obligation in relation to that instalment.
Yes. And we say that we did, and I'm going to come on to the facts to support that. I was in the pleading, I'll just finish that off at page 380. And if one goes to 13.7, this is the re-amended defence and counterclaim. And the issue in respect of my retendering label at trial until developed very late in the day during closing submissions was how this affected the application of Section 50 damages. It was a mitigation point, not a liability point. It was not Uniserve's pleaded case that Hitex's failure to perform the obligations of delivery, so i.e. by having goods available for collection ex works, by reason of Hitex's cessation of manufacturing in mid-July 2020, caused the supply contract to be brought to an end. Uniserve's case was that they'd brought the contract to an end because of Hitex's earlier breach. So that's what we were dealing with at trial. The retendering point was developed, the judge dealt with it, and we made submissions. So the pleading point only goes so far, and it goes to a estoppel, which I will develop in due course. Now, as to the question as to where all this goes, whether Hitex complied with its obligations under the contract, as the judge put it, to have the goods available for collection on or by the agreed dates, which should now be taken to be those in the revised schedule. In my submission, the relevant factual context to answering that question and to the retendering, forgive me if it's an inelegant phrase, but the retendering argument is this. And if we start at core bundle 213, paragraph 271 of the judgment, so by the 7th of June, Uniserve had entered into an alternative contract for the supply with a Chinese company called BYD. We go to 275. The next delivery from Hitex was due on the 7th of June, by which time a further 1 million masks were required to be delivered under the revised schedule. A further 1 million masks were available for shipment on that date, as confirmed by an inspection by Majlan. We then move on to paragraph, I have to move quite far forward, I'm afraid, paragraph 345, but we are going to come back, and that's at page 228.
Forgive me, is it your case that 1 million masks were collected, or that they were not collected?
In respect of the
7th of June?
Yes, they were. That's agreed. My understanding is it's now common ground. That's a third shipment. They were collected on the, I'm going to say 14th or 17th? 17th of June. That's common. So the third shipment was dealt with. The fourth shipment was tendered by Uniserve as found by the judge. That was a further 1 million, but wasn't collected. And that's Uniserve's case. It didn't collect because a Uniserve...
So it was tendered by...
Hitex, I said Uniserve. Yes.
Yeah, so...
I think I've done that.
When you say tendered...
Made available, ex works at the factory.
Well, was available.
Was available. Yeah.
No, I mean,
yes.
I'm sorry. I'm.
No, I see the point. You're driving at.
I'm just being a little bit pedantic about this, and apologies. But I'm trying to make sure that I at least understand whether you're asserting that there was some affirmative conduct, or it's simply a continuation of we had available if somebody had turned up and we could have given it to them.
I'll check that point. There's something in my mind about the evidence on that point, so I won't speak to it right now.
I do know at some point somebody turned up at the factory in a car, and we saw in that email, I think there was some...
Third shipment. Okay, I'm told that Majlan had inspected both the third and fourth shipments, the Majlan being the ground agents.
I understood from the 11th of July emails we looked at that there might have been something that happened more recently than somebody turning up to pick up a delivery a shipment on the 17th of June?
I don't think so, but I will check.
Okay.
I don't recall.
In case I've misread the thing, something somewhere. Yeah,
I
okay.
don't think so.
According to the schedule, the shipment, the delivery of due on the 7th of June was collected on the 17th of June,
Yes.
which was after the 14th of June.
Yes.
So what happened was on the 14th of June, nothing was collected. Is that right?
Correct.
But then they came back on the 17th and took 1 million.
Which was the 7th of June.
And that's been allocated against the 7th of June.
Correct.
So it's then said nothing was collected of the 14th.
Thereafterwards. And the reason there were no further collections, we pick up at judgment 345, page 228 of the bundle. And this was Uniserve's case at the trial, which was by the 17th of June. Dr. Stead, on behalf of Uniserve, communicated to Mr. Popek that the contract was over. At about that date, or shortly thereafter, Mazlan was instructed to have no further dealings with Hightex, and the claimants would have concluded at that point that Uniserve had no intention of further performing the supply contract. The judge goes on to find we've accepted wrongly. That was an anticipatory breach that was accepted. But it's not that part I rely upon, it's those findings. Uniserve said it was terminating the contract, instructed Mazlan not to attend the factory. If we then move to judgment 391 on page 234, in our current case, says the judge, the circumstances are these. By the 17th or 18th of June, Hightex had heard that Uniserve was treating the contract as being at an end. There was still some confusion, but certainly by the 11th of July, the reality that Uniserve was not considering itself bound by the contract must have been clear to Hightex. And at 392, according to the evidence of Mr. Cader, which I believe, Hightex continued to produce as normal for a period. However, Hightex was not informing Mazlan that further shipments were ready. Mr. Cader says because it understood shipments were suspended. And then he deals with the attempts to mitigate in the following paragraphs. And at 394, the judge speaks of Hightex not stopping production, but winding down manufacture. And the point there is that Hightex had, it would say, sufficient stock to meet forward deliveries. Uniserve had not collected past deliveries, it treated itself as discharge, I'll come on to that, and therefore had stock to supply in the future.
I'm sorry, say this again. Hightex had treated itself as discharge.
From the past obligations of, past instalments of delivery. Because this isn't a case where Uniserve had said, can we postpone the delivery dates? Or ask for a period of grace. Uniserve had said to Hightex, the contract is over. As the judge found, Hightex would have understood that to be Uniserve's position, and therefore Hightex must have known. It's the only logical conclusion that Uniserve wouldn't be attending to collect further goods in respect of a contract Uniserve say and plead was brought to an end by them.
So where did you plead, and where did the judge find, if he did, that you had been discharged in relation to earlier instalment?
He didn't, and that's our respondent's notice. What we're saying is the judge should have found, and this is the retendering argument, because if we're discharged from those previous delivery obligations, we would be entitled to retender. And, my lord, it wasn't clearly pleaded, but I can tell you the reason why. The retendering argument was developed by Uniserve during evidence and closing submissions. Now,
By Uniserve?
well, I've taken you to the pleadings. The tendering argument was dealing with mitigation. So did Hightex properly mitigate its loss? Was it entitled to continue manufacturing? Was it entitled to accumulate stock? In their closing submissions, I'm going to find the reference, they then said to the court, well, Hi-Tech simply can't retender, and they relied upon the case of the Stoccia to say that you can't supply the same goods more than once. Now, Stoccia was referred to an opening, but not on this point. So the case in regards to retendering for liability was developed during the course of trial. We tried to deal with it in closing submissions. But it's right to say, my lord, that it wasn't clearly pleaded in that way, because we were somewhat taken by surprise on the liability side of things.
But if you had been discharged
Yes.
in relation to an instalment, it seems to me that no question of retendering arises. You're entitled to do what you like with those goods.
Oh, but you're correct, but
So it's not a matter of retendering at that point. But contrary to what you said, your respondent's notice does not say that the judge should have found that you were discharged. There's no mention of discharged in your respondent's notice. Page 112.
thank you. Well, was obliged to maintain sufficient stock to fulfil all deliveries that had fallen due. So the judge was wrong to find that we had to keep those goods. That's, if I've not expressed it correctly, then apologies, but that's the point. The judge found we did have to accumulate stock. We were not discharged, and we're saying he got that wrong.
But your case was and still is, as I understand it today, that you had a cumulative obligation. You just took us to the schedule, saying you had enough to deliver on the 5th of July. Well, that's on a cumulative basis.
Yes, it is.
So you're not mounting the case that you were discharged in relation to the 14th of June, 21st of June, or 28th of June.
We are.
Or
We are, because by the 12th of July, I think it was the 11th, I took you to the paragraph a moment ago, the judge found that Hi-Tech would have known the contract was over. And then he says, until that point in time, we treated it as suspended.
But if you were discharged of in relation to the previous contracts of 14th of June, 21st of June, and 28th of June,
Yes.
there's no problem, because that's 12 million you're discharged of. So there's no question of not having enough goods. You've got 12 million.
I quite agree. The retendering
that are not spoken for.
The retendering is in respect to future deliveries from the 12th of July.
No, but as you said, that we're not concerned with that, because the Uniserve case is that they accepted your repudiation on the 11th of July.
Yes, but they wouldn't have been entitled to accept a repudiation on the 11th of July because the schedule demonstrates that we had sufficient stock to meet the deliveries up to that point in time. But as the judge found.
What difference does it make then that you knew from 11th or 12th, excuse me, 11th or 12th of July that Uniserve were not going to perform, because your case is you elected to keep the contract open, in which case why doesn't it remain open for all purposes?
Well, in our submission, it remains open in respect to future deliveries. There's no doubt we had to supply goods for the future deliveries, but we're not suggesting we were released from that obligation. What we are saying is in respect of the historic past deliveries that were non-collected and we say rejected by Uniserve, we were released from supplying those goods.
So until the 11th of July, you had an obligation to supply the cumulative total, but because of a repudiation which was not accepted by you, you were discharged from part of the contract, i.e. that was that which was in the past, but the future performance remained alive and you were entitled to do what we've been calling retendering.
Yes.
That's your analysis, is it? So that's all.
It is.
That's all the consequence of what we're generally told is a thing writ in water.
That is our analysis, and that aligns with Section 50 of the Sales of Goods Act, which I...
Hang on, now I'm confused, and I'm sorry to... I thought your analysis of the contract was that on each scheduled date for delivery, it was Uniserve that had an obligation to turn up, to act in accordance with Clause 2.
Yes.
And if they didn't, my understanding was that your argument was that in relation to each delivery date, you could, without more, sell those goods if you'd have chosen to do so
Yes.
the following day.
Yes, the judge found...
And I asked you yesterday, does that have the consequence that your total delivery obligation was not 80 million, but on each occasion in which Uniserve didn't turn up, the total delivery obligation would have correspondingly gone down and down and down and down.
Yes, and I said as a general...
I understand it, the answer that you've just given to my lord, which was different, which is that there was some change. So I'm sorry, it may be me.
Yes, and the reason... No, I see the point. The reason is the judge found at 392 of the judgment that in respect of past missed deliveries up until the 12th of July, Hightex thought they had been suspended. That's what the judge found. That's on page...
Well, never mind what the judge found or what Hightex thought. What is your case as to the status of deliveries which were not collected by Uniserve on the date in the revised schedule?
Up until the 12th of July, we were accumulating stock. The contract we thought was suspended, but we may be required to deliver. At that point in time, when it was clear, crystal clear from Uniserve that they were not going to attend any further collections.
But when you say you thought the contract was suspended, I'm not sure I know what legal concept that is, but why do you say you could be required to deliver? You mean, notwithstanding that they failed to turn up at the time they were supposed to, you might be in fact required to deliver that amount? I thought that runs contrary to what I understood to be your case, which was that you could, in respect of each... I will admit it.
Sorry, I'm fidgeting too much.
Sorry, I will sort of... So I'm just trying to get my own thought out there, and then you probably want to have a word. But I thought that you said that in relation to each delivery obligation, which you say is severable, that once they'd missed the collection point, you were free to do what you wanted, had you so chose, with the delivery amount. And I'm struggling to understand why you would then say that they would be entitled to, as it were, reinstate a requirement on you to deliver something which ex hypothesi you might have sold.
My lord, I see that. And I suppose the answer is that the judge has found that by about 11th of July, Uniserve had said through Dr. Sturd, contract's over. On that analysis, Hightex would be discharged from the past deliveries.
But can we get away from what the judge thought?
Yes.
Just for a minute. As my lord said, can we actually just... What do you say?
Well, Hightex were treating, and you're right, what is the legal analysis of that, but the contract is being suspended. In other words, an indulgence in respect of those deliveries. So had Uniserve called on the deliveries up to the 12th of July, Hightex would have met. It was producing and it would have met.
But voluntarily, not by reason of contractual requirements.
Yeah.
So you say it had the liberty, had it chosen to do so, to sell the undelivered instalment. But if it hadn't done so and had it there, if Uniserve had rocked up and said, please can we have belatedly that instalment, you would, as a matter of voluntary behaviour...
Yes, mitigation, whatever the case may be.
Given that.
Yes.
Right.
But post the 12th of July, stopped manufacturing on the premise that Uniserve had asserted that they would no longer turn up to collect any further goods.
So a lot of this case hinges around this question, but as I am beginning to see, I think a lot of the case hinges, this analysis all hinges around the question of whether this is a cumulative contract or a severable contract.
Yes.
I mean, an awful lot of this analysis we're going through keeps coming back to that same point.
Well, it is. And
Well, the judge said it wasn't severable, so where in your respondent's notice or your skeleton argument do you challenge that?
I'll have to look at the skeleton argument, but my lord, I think it's a fair point. I don't recall there being a specific challenge in respect of that.
No, I don't either. Okay.
Yes, I mean, I go back again to the Benjamin extract, where we're not saying that we are entitled to terminate the contract as a whole, but there is a severable breach that we're entitled to action, and that's where Section 50 comes into play. Can I take you to Section 50 now? I tried to yesterday.
And incidentally, I had misread that email, and so that was a wild goose chase I was trying to send you off on in relation to the somebody attempting to make a collection at some later point on the 14th of June. It was, I think, apparent that the car rocking up to 2 cars, in fact, was all to do with the delivery of 1 million, which took place on or around the 14th of June, I think.
Well, thank you for clarification.
So I'm sorry about that. I was a wild goose chase there.
So Section 50 is found in the Authorities Bundle, tab 23, page 552. Title is Damages for Non-Acceptance. Section 50, subsection 1, where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may maintain an action against him for damages for non-acceptance. Subsection 2, the measure of damages is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. Subsection 3, subsection 3, the prima facie measure of loss. So where there's an available market for the goods in question, the measure of damages is prima facie to be ascertained by the difference between the contract price and the market or current price at the time or times when the goods ought to have been accepted. So that's the key point in time for the purposes of Section 50. In my submission, that means non-acceptance or rejection of an instalment triggers an action under Section 50 for damages. The section deems mitigation. It effectively applies the common law and codifies the common law. It assumes that where there's an available market, the seller can and has sold the goods in the available market at a price. But if that's right, that the seller is free to sell the goods and must sell the goods in the available market, well, those goods can't at the same time be held to supply under the original delivery or supply contract. The seller must be free to sell those goods on non-acceptance. That's what the section...
Well, these are non-fungible goods, aren't they?
Yes.
So...
Sorry, fungible. Forgive me.
They're fungible goods. So unless they've been specifically allocated to the contract, this doesn't arise, does it? Whether these particular goods can be sold. And you haven't allocated any particular goods to this contract, to a particular instalment.
Well, saving to the extent the goods are in the warehouse, the palleted goods, they're in the warehouse on the available date to be collected by Uniserve.
Yeah, but you've got millions there, and they're only obliged to collect 1 million. So
yes,
the fact, so you can't say which of that million And you're not suggesting that you have gone and got 1 million and put them by the gate and said these are allocated to the contract. You didn't say that.
No.
So there aren't any allocated goods. So I don't think the question of not being able to resell those goods arises. They aren't allocated.
I mean, as I understand it, I've always understood that this is actually a fiction anyway.
Section 50, subsection 3.
Yeah.
It is a fiction, yes.
So you don't actually have to, separate out and or indeed sell into the market at all.
It's deemed, yes.
It's just a deemed method of calculating contractual loss.
Yeah, I agree with that.
How does Section 50 work when the time for acceptance is not of the essence? So you have a delivery date in the revised schedule, but the buyer doesn't have to collect the goods on that date, and if he doesn't collect them, then it remains the seller's obligation to keep them available unless and until the seller gives a notice making time of the essence and the buyer then fails to collect them. So you can't say, can you, that as of a particular date in the revised schedule, there has been a wrongful neglect or refusal to accept and pay for the goods in as contemplated by Section 51. That would only, 50 subsection 1, that would only happen as and when time is made of the essence and the buyer has still failed, wouldn't it?
My lord, no. Making time of the essence would entitle Hightex to treat the contract as at an end. It doesn't disentitle Hightex to claim for a severable breach of an instalment. Again, that was the passage we were looking at.
Yes, but the assumption underlying certainly the prima facie rule is that the buyer is now free to do what he wants with the goods. Whereas if time has not been made of the essence for collection, the seller is not free to dispose of those goods because the buyer might turn up and say, I want them.
Well, in my submission, the buyer, the seller, forgive me, is free to dispose of those goods. There is a fixed date for delivery in the contract. We see in the clauses Uniserve must turn up on that date at the premises to collect. That's Uniserve's obligation. If Uniserve breaches that obligation, there's an action for damages, not, as I say, to terminate the contract.
Well, just a minute, forgive me, that's equating non-collection with rejection or non-acceptance, and they're different concepts.
They are, which is why I took you through the factual context where Uniserve had effectively said, we're not intending to collect goods. And I said to you that that is a point of rejection.
So you say making time of the essence, you say, is only relevant for the purposes of whether there can be termination.
Of the contract, yes.
Of the whole.
Of the whole contract.
So your analysis is that, sorry to go over this again, your analysis is on the very day in the schedule, if Uniserve doesn't, in accordance with clause 2.2, have somebody turn up to collect, you could sell an equivalent proportion if you wanted to out of your warehouse, and then say when they turned up the following day, sorry, too late, I just don't have any obligation to deliver to you at all.
Yes.
I thought that's not what you just said. I thought what you're now saying is that there was more than just mere non-collection, but that they actually rejected the goods by virtue of indicating to you that they were not going to collect them.
Well, it is what I'm saying, but the label we're putting on that is a rejection of those instalments.
Yes. Well, where do you plead that?
Well, as I've candidly accepted, it wasn't pleaded as a rejection because the way the point emerged was through the evidence. The retendering to liability point, in other words, we didn't manufacture, therefore that's an intellectual liability, wasn't taken in the re-amended defence.
So what are the facts you rely upon as rejection of particular instalments? Those
that I've just taken you through.
The fact that they were saying that the contract was over.
Yes. Yes, and coupled with the failure to attend on each and every date to collect goods past and then future.
Right. Okay, so that's, I mean, have you said what you want to say under this heading, or is there...
I have under that heading. I then want to deal with the estoppel point that I trailed. And this is in our skeleton argument. What we say is that if we're wrong on the...
Can you just point me at the paragraphs of the skeleton?
Forgive me.
Oh, it's all right, found it. Page 125.
So if there is a prohibition on retendering in the way that we say, the doctrine of estoppel we submit provides an answer. And we refer to the Furco metal case, Authorities tab 10, page 235.
Before we look at the law, can you just spell out the nature of the estoppel? Is it an estoppel by representation?
Representation,
What's the representation and what's the nature of the reliance?
The representation are the facts that I've just set out, which is...
Could you be more precise?
Yes, I will. Yes, I will. So, by Uniserve's words or conduct, the words being we're not paraphrasing, but we're not going to collect goods, the contract is over. And by their conduct in not attending to collect goods, that was a representation to Hightex. Hightex was not required to accumulate stock to meet past non-accepted, rejected deliveries.
And that representation is made when? Are you looking at I've forgotten the date, June or the 11th of July or which?
Judgment 391 by the 17th or 18th of June. Hightex heard that Uniserve was treating the contract as at an end. The reality that Uniserve was not considering itself bound by the contract must have been clear to Hightex at a later date. That's on page...
When you say by 17th or 18th of June, Hightex had heard from whom? I mean, it can't be an estoppel unless it's heard from Uniserve.
Yes, and that goes back to Dr. Stead's communication at Judgment 345. Dr. Stead communicated to Mr. Popek that the contract was over. And that's, the judge says, about the 17th of June, so that's the communication.
So that's in fact the estoppel. I mean, it's that or the letter of the 11th of July.
Yes, and the conduct.
It can't be the 11th of June, can it? Because if you're relying on paragraph 391, the judge's very next statement is there was still some confusion, which is not a great start for a case of unequivocal representation.
Yes, at 391, correct, but there was still some confusion, but certainly by the 11th of June.
So it's the 11th of July.
The representation was made earlier. It had crystallised by the 11th of July, but coupled with the non-attendances in the meantime.
What this amounts to is you're saying that a party says to you they're not going to be bound by the contract, and your effect, what you're saying is that you can accept that in part, but not in whole. In other words, you can treat part of the contract as over, but not the rest. It's a partial, but really it's espousing the concept of partial acceptance of repudiation.
But we're looking at it through the lens of estoppel, which takes me into the Furco metal case. Which is Authorities, tab 10, page 235. And through to page 252. Between G and H, and this is Lord Ackner. It's always open to A, who was refused to accept B's repudiation of contract and thereby kept the contract alive, that contend that in relation to a particular right or obligation under the contract, B is a stop from contending that he, B, is entitled to exercise that right, or that he, A, has remained bound by that obligation. If B represents to A that he no longer intends to exercise that right or requires the obligation to be fulfilled by A, and A acts upon the representation, then clearly B cannot be heard thereafter to say that he's entitled to exercise that right, or A is in breach of contract by not fulfilling that obligation. And in our submission, the facts of this case found in estoppel. Uniserve told Hitex the contract was over. Hitex stopped accumulating stock, tendered those stocks for forward delivery. Uniserve cannot be heard to say thereafterwards Hitex is required to meet those past missed deliveries.
Was this estoppel pleaded?
No, it wasn't, but for the same reason as I mentioned earlier, we were not dealing with the retendering. I'm going to find a different...
It's also not in your respondent's notice, is it?
It may not be in those express terms. It's in the skeleton argument, but it may not be in those express terms in the respondent's notice.
But what this is saying is that the party who has said that he no longer intends to exercise the right, etc., can't later turn around and say, well, yes, I do expect you to perform, you're in breach or whatever.
Yes.
But that is a shield, isn't it?
I'm sorry, I mean.
That's a shield. He can't turn around and enforce against you your obligation.
Yes.
But you're trying to use it as a sword, aren't you? Because you're saying that means that you can sue for damages for his breach, even though you haven't accepted the repudiation.
Well, our pleaded case would have been the retendering argument. If the defence came in, the defence averred that one cannot take that point because it doesn't work and so on and so forth, the reply would have been you're stopped from taking that point, contending that we're required to accumulate stock to fulfil past deliveries.
Was there evidence from your side that, along the lines that we thought the contract was still alive, despite what Uniserve had said to us? And the reason we ran down production was because we thought we were discharged from past deliveries, and therefore we relied on this representation, or any evidence along those lines.
Bear with me, I don't want to misspeak. I'm told, and this rings a chord, that the evidence was that because Uniserve were no longer picking up, manufacturing was wound down as a consequence. And
That might be because they thought the contract was over.
well, no, that's why we kept stock to meet future deliveries, and we were not saying to the judge, this is the ground one of the appeal, that the contract was over. We're not saying there was a termination and that was accepted. We're saying...
I know you're not saying that now and in the litigation, but the question of reliance depends on what people were thinking at the time as the reasons why they did what they did. And I was just wondering whether there was any evidence about that, and if the point wasn't pleaded, what opportunities for cross-examination there were on the Uniserve side to challenge a reliance point, which they might not even realised was being run.
My lord, I hear what you say, and I take the point. And in an ideal world, if all issues were on the pleadings, the case would have been run differently. But as my learned friend yesterday said, cases are dynamic, issues develop through the case, and we're trying to respond to the issue that developed. I've said clearly it wasn't pleaded. We were not taking that point at the outset. It arises as a consequence of the retendering point.
Okay, thank you.
My lord, those are my submissions on ground one, unless there are any further questions. But there have been quite a few.
Thank you, thank you.
I can take ground two more swiftly. In our submission, notwithstanding, so ground two, just to orientate the court, the letter friend says that the judge's decision on damages was infected by his decision on liability. And I can see that because the judge was looking at damages initially through the lens of an anticipatory repudiatory breach of contract, although he did apply section 50. In our submission, the judge got to the right answer, although he misapplied the labels. So notwithstanding, my lords, that the judge erred in finding that the contract had terminated on or about, I think, the 12th of July 2020, on grounds of Hitex's acceptance of an anticipatory breach of contract, he nonetheless assessed damages under section 50, and we see that in his judgment, beginning at paragraph 406, page 237. So we see at 407, the judge expressly considered section 50, and at 408 considered the prima facie test under section 50, subsection 3. And at 411, the judge recognised that the overarching provision was section 50, subsection 2. And he says, in applying that test, one should look at the actual loss to the seller, which for Hitex is the loss of the bargain to sell the remaining 77 million masks at a price set in the supply contract for delivery by the date set out in the supply contract. At 412, he says, Hitex was under an obligation to mitigate its loss. If there was no market for a single contract of 77 million masks delivered over the term of the revised schedule, but there was a market at or after each point at which a delivery was due under the revised schedule for a number of masks to be delivered on that date, and that goes to my Lord Justice Miles's point yesterday, there may not have been a forward contract for 77 million at that time, could suppress the market, but there may be multiple smaller contracts by which the masks can be pieced out. The judge said the price that could have been achieved on those dates, being the forward dates, would nevertheless be relevant in fixing Uniserve's liability, and he sets three questions for himself at paragraph 413. The first question he asks is whether there was effectively one forward contract for 77 million masks.
That wouldn't be section 53, would it? That would be a mitigation.
Well, yes. I mean, section 53 deems mitigation, but one still has to ascertain whether there's an available market at a given date and set a price at that given date.
No, section 50 subsection 3 looks at the market price on the dates of the revised schedule.
Yes, forgive me, that's
whereas
2.
the judge's paragraph 1 is looking at a single contract at the date of the acceptance of repudiation.
Well, yes, but on or about the dates for in the revised schedule. So he's forward thinking there. So is there a...
Yes, it's a contract in July for forward delivery.
Yes. So one then would have to set the price by reference to the forward delivery dates.
Yes.
And at 2, he's considering where there's not one contract, but perhaps multiple contracts, whereby the seller could perhaps piece out the masks over multiple contracts, again, over the delivery dates in the revised schedule. He's considering that hypothetical, or that situation too.
And which of those 2 possibilities does he apply?
Well, it's not the model of clarity, the judgment, but I'm going to come to what we think is the analysis. And I'm sorry, that's the best we can do. You'll read this section, you'll make of it what you make of it. We've interpreted as I'm going to submit now. The judge then sets out at length, in fact, I'll just finish 413 sub 3. If in either case there was such a market, what was the correct price or current market price that might be achieved for this? And then he sets out his analysis as to available market on given dates and available market price. Before the court was expert evidence, it wasn't particularly helpful. The judge remarked it was of no use, but judges often have evidence, I'm afraid, that isn't too helpful, and they do the best they can with what they've got in respect of fixing damages or the price. His conclusions come out at 447. And what he says at 447 is, I'm obliged, having said the evidence isn't wonderful, I'm obliged to make a determination notwithstanding the less than satisfactory evidence that is presented to me. Whilst by the end of July, I consider the public sector demand for masks had been substantially sated, I consider it would have been possible for Hi-Tech to sell masks during that period had it accessed appropriately connected wholesalers, in the plural. It would have been possible to sell wholesalers accessing the retail markets, albeit at a price that would need to be competitive with non-medical grade masks. There would probably also be an ability to sell to public sector buyers across the world. And again, this is plural. So in our submission, what the judge is finding here is that there was no one contract for 77 million masks. You'd have to sell to a variety of wholesalers and or public sector buyers across the world. And what he then does is deal with the price that could be achieved in respect of those sales. And that, we submit, links back to 413 sub 2, which was the second situation. And the judge found that the available market price was 8 pence across board. Cents, thank you. What he didn't do was fix...
No, he doesn't. He says that's the profit.
Yes, but that's the available market price. That's the price that it could have... So the difference, for the purposes of damages, is the difference between 8 cents, what they could have been sold for, and the 30 cents being the contract price, which is how the judge gets to 22 cents per mask. And it's not, I say it's not the easiest of reads, but the calculation is based on 22 cents times 77 million. What the judge didn't do was in respect of the previous missed delivery date, so those from 14th of June, he didn't set a price in respect of, well, he set 8 cents in respect of all. What he didn't do was say, well, actually on the 14th of June, it might have been 6 or whatever. The position to the judge from Uniserve was he needs to look at this month by month, not schedule by schedule. That might have been an impossible task. This is PPE in the height of the pandemic and so on and so forth. But it seems to us that the reason the judge didn't set a price at an earlier date, and it goes back to the suspension point, because Hi-Techs were holding masks up to the 12th of July in order to fulfill the contract. Had Uniserve come along and said, well, can we have the masks? And that's the point in time he says, well, Hi-Techs was acting reasonably and started to mitigate, and therefore it seems to us, you may take a different view, but it seems to us on reading the judgment, he's fixing one price for the entire period based on the facts of this case. And he's saying, that's the best I can do. But also remember that contract was for, I think it was 3 months. From the 12th of July, the contract had only 5 weeks to run to the 24th of August. There were multiple deliveries scheduled, but it's a short contract. We submit the judge did the best he could with the evidence available and came to a conclusion that 8 cents was the appropriate price for the entire period. My Lord, those are my submissions on ground 2. Ground 3.
I can short circuit that. Having reflected overnight, I abandon ground 3.
There you go.
Ground 4. The 15% point.
Yes.
Can we start with my learned friend's grounds of appeal? Core bundle, page 62. And the way the ground 4 is framed is the judge's failure, sorry, page 62, core bundle. Is the judge's failure to consider Uniserve's pleaded case on termination. And what they say its pleaded case was this 15% point. Well, with the greatest respect, I've analysed the pleadings. There is no 15% point pleaded. And in fact, my learned friend accepted yesterday the point emerged in the evidence and then was dealt with in closing submissions. There was no pleaded case. The government of Jordan requisitioned masks and or required a 15% retention, as a consequence of which Hi-Techs was unable to meet certain delivery schedules. Now that only goes so far. The judge dealt with the point. I'm not taking a technical pleading point, but I'm just setting out the background, because the judge is criticised for dealing with this in short form, but there was very, very limited evidence on a point that wasn't pleaded that emerged in cross-examination.
Well, Mr. Parsons says the judge didn't deal with the 15% point, but
Yes.
dealt with a different point, namely that everything was
The full requisition. And I'm going to deal with that. In our submission, that's not right. In fact, let's turn to that point now. If we turn to the judgment, paragraph 336, subparagraph 4, that'll be core bundle 226. At 336, the judge is dealing with points that Mr. Walsh invited him to deal with in respect of the production reports. And he sets out some of the points there. And we see at 336 Roman 4, the judge is dealing here with what he says is the legal requirement to supply, a legal requirement in Jordan to supply customers in Jordan. That's important, customers in Jordan. Now that's not the requisition point. I'm going to deal with that now. If we look at the closing submissions, we keep one finger in that, but the closing submissions that were made by Uniserve, here we have to go into the supplemental bundle, page 249, tab 32. In fact, if we go through to page 251, paragraph 53 is where I'm looking. Paragraph 53.
So we're in the supplemental bundle.
Yes, my lord, sorry. So page 251,
1, did you say?
supplemental bundle 251, paragraph 53. I hope my reference is right. It should begin fourth. Yes.
Yes.
These are the closing submissions of Uniserve. They say, fourth, the requisition of Hitex's mask by the Jordanian government, or at least the requirement to supply a minimum 15% stock. So the point's in play. We can put that bundle away. And then if we go back to core bundle, page 226, judgment 336 sub 4, we read here that the judge says, if there had been an occasion when Uniserve had turned up to collect the masks that were in the warehouse and they were unavailable for one of these reasons, being the reason set out above, then there might be something to this point. However, without having tested this point in that way, Uniserve cannot demonstrate that masks that were shown as available in the production reports were not in fact available to it. Hitex might have dealt with the requirements of other customers and of the government of Jordan out of the reduction in numbers of masks. Now, pausing there, that cannot be reference to the requisition, because the requisition case was all masks have been requisitioned for the government of Jordan. The 15% issue was 15% of masks must be reserved for the local market. And if you see the subheading, sub 4, the judge is dealing with the legal requirements in Jordan to supply customers in Jordan. That's the 15% issue, not the total requisition. The judge is making two findings in this paragraph. The first finding is that the 15% point isn't a good one. He then says at the end, if Uniserve's case is that Hitex could never have met the contract because its stock was being requisitioned by the government of Jordan, it's not enough to establish that case. So there are, in my submission, two findings dealing with both of the points raised in Uniserve's closing argument. That's the extent of the judgment on that point, but that, in my submission, is a consequence of how the point arose. So in essence, our primary response to ground 4 is that Uniserve is trying to open up factual findings. It's not open, we submit to this court to do so. There's no suggestion that those factual findings were absurd or couldn't properly have been made. There's a second point. The judge's conclusions were right as to the 15% point. It doesn't follow that Hitex could not meet its obligations to Uniserve. At 338 of the judgment, the judge finds that the production reports are probative of the numbers of masks in Hitex's warehouse, the contemporary documents that were produced for a proper commercial purpose. There's no evidence that they've been tampered with. Now, Hitex relied upon the production reports to demonstrate it could fulfill orders. The judge has found he accepts those documents. There was sustained challenge to that, but the judge came down in Hitex's favour.
If the judge is concluding that they are probative of the number of masks in the warehouse, contemporary documents that were produced, etc., then how is that consistent with his view that they may not have included 15% allocated to the government.
Well, should we look at the evidence? And I can come back to that. I'll just take you through a couple of passages of evidence, and I'll take you to the finding, or the evidence we
So I thought we were shown, forgive me, I thought we were shown that in the evidence that your client accepted that the production report showed all masks in the warehouse, whoever they were allocated to.
Which I think, sorry, I think isn't that what the judges found at 336 in the first bit of sub-4? My understanding is that the production reports were gross, if you like, and the evidence was that they would have included any 15% reserved for.
Well, yes, at 3363, the judge also found that there was on occasion a temporary lag in updating the production.
Yeah, but putting that aside,
yes.
Just on the 15% point, my understanding throughout has been that the production reports we've seen are gross numbers, out of which, if there had to be a reservation of 15% for the government of Jordan, I appreciate there's an issue about that.
Yes.
That would have to come out of the numbers shown in the production report. And that's what I thought I understood.
That's
the judge saying at 336 sub 4.
Yes, well, there's going to be a nuance to that, but on the face of it, we rely upon the production report as to what's available on any given date, and therefore you're right. If there was a requirement to ring fence 15%, it would be taken from that number.
So can we just see where you are on the if?
Yes, I'm going to do that.
Is your case that there was no reservation of 15% and you can simply take the figures in the production reports and all of it was available for Uniserve? Or is your case that there did have to be a reservation of 15%, but nevertheless you still had enough?
Well, there was a letter of the 18th of February, which I'm going to take you to, that told High-Tech that it would have to make a commitment of 15%. There is then a subsequent letter, Defence Law 2, which imposes, so Uniserve would say, a full requisition. The question is how those two can coexist. We're going to take you to Mr. Kaler's evidence. Mr. Kaler's evidence was that unless and until the government of Jordan requested 15%, High-Techs were free to use all of the masks in the warehouse. And in my submission, he says that in clearest of terms. And that's the very limited evidence we have on this point. I'm going to take you to that now.
Right.
So we'll have to go into you looked at it yesterday, but we'll go into the transcript, day 2, so it's supplemental bundle.
It's the same passage we looked at, is it?
It is, so it'll be page 327.
Yeah.
Page 25, reading down. Line 16. Question about 15% had to be retained in case the Jordan Ministry of Health came and said that they wanted it for government or military use. Yes, regarding the 15%. And there's also a slight language barrier. English is not Mr. Kader's first language, but you'll read that from the responses. And Mr. Al-Grabili had an interpreter in court as well. Yes, regarding the 15%, when we're looking at any quantity available in the warehouse, we are reserving always a 15% of that quantity in case the Jordanian government came and they asked to collect quantities for, and the judge intervened. So does that mean that quantity was the Jordanian share was reflected in the sold figures, or was it taken off the top before the starting number? No, it was just reserved. And this is the point. Whenever they are coming to ask quantity, it will be calculated from the quantity available. So only when they come to ask for quantity does High-Tech then determine what that 15% should be. Then when it's taken out, it will be reflected on the second day on sold. Right, says the judge.
Forgive me, going back, that's inconsistent with it, what he said above, that we are reserving always, when we are looking at any quantity, or we are reserving always a 15% of that quantity.
Yes, this is an explanation as to what he means, which is, and if it carries on, we'll just read his response to the judge, and the judge tries to clarify the point. Right, so if we look at page 1777, answer 610, the number there, 86,984, is a number that might have been reduced if the Jordanian authority had said, can we have our 15%? So it might have been reduced, said the judge, if the Jordanian authorities asked. Yes, says Mr. Kader. But until they ask, you're regarding it as being available to sale. Now, whether or not as a matter of Jordanian law, those goods were available for sale, we just don't know.
It's just a matter of logic. The whole concept of reserving a quantity of 15% in case the Jordanian government came, so it seems to be inconsistent with saying, if the Jordanian government hasn't actually turned up and said, can we have 15%, he would have been free to sell the lot.
But that's what happened in practice. There was no evidence the Jordanian government ever came to request 15%.
But his evidence seems to be, I think all of us thought this yesterday, that this was evidence that was sort of just factually inconsistent. Because if he's saying, we always reserve 15% of everything that was in the warehouse in case the Jordanian government came, the whole concept of reserving means you can't just sell it.
But Mr. Kaler's...
But then he says, but in fact, if they didn't actually turn up on a particular day, and if somebody else had come and said, can we have the lot, they would have sold it.
My Lord, I see your point, but it's what Mr. Kaler believes. Mr. Kaler is saying on behalf of Hightex, we could sell these goods unless they're asked for by...
Well, he's saying inconsistent things, isn't he? First he says, we kept it in reserve. Then in response to the judge, he says, we didn't keep it in reserve. Then in response to Mr. Walsh, he said, we did keep it in reserve.
My Lord, I hear what you say, and it's for the judge at trial to determine which of those accounts he prefers.
And what did he decide?
Well, that was the paragraph I took you to, 336 sub 4, which was simply Uniserve haven't made out their case about non-supply to Jordanian customers. And that's the extent of the finding on these issues.
But do you accept that if 15% was reserved for the Jordanian government and was not available, then there wasn't enough to meet the cumulative total?
No, I'm going to come on to that as my third point. But to finish in the evidence, on day 4, page 331, page 30, line 6. So here Mr. Al-Grabili is being questioned by Uniserve's counsel. And at line 6, the document from the Ministry of Health is introduced. Now that's the 26th of March document you looked at yesterday, which was the total requisitioning document, which was obviously 5 weeks after the 18th of February 15% commitment letter. Please bear with me a moment. Page 31, internal page, forgive me, 31 on page 331, at line 17, Mr. Al-Grabili is asked whether he received that letter, to which he says, yes, because I had a meeting with the minister and he gave me the letter was the question. Yes, after the meeting he signed it and gave it to me. Then there was the question regarding Mr. Cader's evidence retaining 15% of production in case the government wanted it. Do you remember him saying that? Yes, there is a letter.
So Mr. Walsh and is this Mr. Al-Grabili? Both thought that was what Mr. Cader's evidence was.
My Lord, with respect, it's not fair to draw that conclusion. Mr. Al-Grabili had an interpreter throughout the trial. That wouldn't be my submission a safe conclusion at all. In the flurry of cross-examination, you say, yes, I remember, but there was an exchange about that, no more, no less.
All right. Well, Mr. Walsh speaks English anyway.
I'm sorry?
Mr. Walsh speaks English, that's his understanding of the evidence anyway, even if not Mr.
Well,
Al-Grabili's.
Yes, but that, with respect, is not
Yes, okay.
there. We've then got at line 25, but here we see Uniserve's confusion as to the case that it's putting. But, says Mr. Walsh, from the 26th of March, all face masks that you were producing actually legally belong to the Ministry of Health. That's right, isn't it? So is it Uniserve's case that the 15% requisition had fallen away because it had been superseded by a defence law? It would appear to be, because you can't have a 15% requisition to supply to the local market, retention to supply to the local market at the same time as holding each and every mask for the Jordanian government. Not for local market, but fully requisitioned. And you have Mr. Al-Grabili's answer, but in respect of that question, which was, no, that's not what it means. And he goes on to explain why. So the point I'm endeavouring to make is that the point emerged late. It wasn't pleaded. There was very limited evidence in point.
Well, I don't know if you finished taking us to the evidence, but there's the answer at the top of page 34 of the internal pagination, and then at page 35, lines 9 to 12, both of which seem to be clear acceptance that they have to reserve 15%, don't they?
Well, but yes, but then there's speaking as to Defence Law number 2 and what that actually means, and whether that means that the masks in the factory are not available to be sold to Hightex. And if one reads down Mr. Al-Grabili's, and I'll find the passage, evidence, is that, in fact, this is on 333, page 37, lines 4 to 11, where the question was put that masks that they were manufacturing, that they didn't have personal approval, were in fact legally belonging to the Ministry of Health. No, says Mr. Al-Grabili.
So I'm lost where you are.
It's on page 333, supplemental bundle, internal page 37, lines 4 to 11.
Oh, yeah.
Well, Mr. Al-Grabili's response to the point that was being put to him, which was that they couldn't make available any of the masks because they'd all been requisitioned, was no, that's not right. We only had to keep back 15%. And that's the structure of his answers to Mr. Walsh's questions, isn't it?
In my submission, that's not what Mr. Al-Grabili is saying.
No. Okay.
He's consistent with what Mr. Cader is saying, which is only if we're asked for those masks do we then have to fulfil that requirement. And as I said, whether their understanding of the letter or defence laws were correct or incorrect is, with respect, neither here nor there and wasn't tested. It's what they believe. And the point being, if they did have to reserve 15%, but they still made that 15% available for Hightex, that might have put them in trouble with the Jordanian government. I don't know where that would have gone, but it doesn't follow that they can't do it.
Well, it works both ways, doesn't it? If they were supposed to under the law, but they didn't, then the masks were available. Conversely, if the law didn't actually require them to, but nevertheless they did reserve them.
Well, yeah, yes.
So
Yes, but
either way, it's what they thought
it's what
they
they
had
thought,
to do.
and that's the point. Subjective, exactly what they thought they had to do. And Mr. Kaler says, I understand there's inconsistent accounts in the short evidence that we had. His view was only when they come to ask. And if one takes a step back, that makes sense. Because if the government doesn't come to ask for masks at any given point, they're not just accumulating 15% on a rolling basis, they're selling what they've got. That's what happened in practice. There was never a request for masks. There's no evidence that ever came to pass. So he's unforgiving.
Yeah, I mean, so what you're saying is there were two phases, and this was put. The first is at the start of the pandemic, keep 15%. Second phase, actually, we just own it all. And the evidence, you say, pretty much amounts to the fact that High-Tech's just basically thought that doesn't actually mean what it says. It just means that if at some point they come,
Yes.
we might have to give them some masks.
Y-
But unless or until they do actually come,
It's exactly
we can do
that.
what we want. In fact, including entering into a contract with Uniserve.
Not only can we do, but we did. We
Well, I
did
know they
do.
did,
But yes, indeed, we did do what we wanted.
They
Yes, but remember, my
regarded
lord,
themselves notwithstanding the requisition, which I think predated the contract.
but I think this is common ground. The contract was approved by the relevant Jordanian authorities, and on each and every occasion when masks were going to be exported, High-Techs had to go to the government department. They had to declare what they were shipping out of the country. They received various stamps, letters of authority, and then the goods were shipped. There was great swathes of evidence in regards to that.
And that's what is that what he's talking about at the bottom of page, internal page 36, 332?
Yes, exactly that. And it was never suggested that High-Techs were acting somehow illegally or selling masks that they shouldn't be
Well,
selling.
that's not inconsistent, is it, with an obligation to keep 15% of the government? I mean, the government can consent to you selling to Uniserve, nevertheless be saying, yes, but you must make sure that 15% is retained for us.
Well, we have that one letter. The problem is, because it wasn't properly pleaded, there was no further factual inquiry in advance. So from the government agencies, what does this mean? What happened in practice? What's the position in Jordanian law? The point, I come back to this because it's a point of fairness. It just wasn't developed until cross-examination.
Your point, anyway, is that the judge, the extent of the judge's finding at 336 sub 4, is that it was for Uniserve to demonstrate their requirements couldn't be met by reason of some government requirement.
Yes.
And they haven't proven, as a matter of fact, what that was.
Yes, but if evidence is inconsistent, the judge is entitled to come to a landing one way or another,
And
unless it's
he just says
absurd.
he deals with it in terms of stock being requisitioned, whether that's as to the whole or 15%. You say he just didn't find that case proven.
Well, yes, but if you read earlier in the passage, he refers to supply going to the local Jordanian market, and that's consistent only with the 15% case, because you'll remember the 18th of February letter was a commitment to supply the local market. The text of that letter, because it may help, actually is on 34, so page 332, bottom of page 34, lines 18 to 24.
So okay, so that's the local market requirement. So you're saying that in 336 sub 4, the judge is effectively dealing with both the 15% and the requisition, what we would call a requisition of all.
Yes.
Collectively, you're just saying whatever it amounts to, Uniserve haven't proven that any part of the amount shown in the production reports were earmarked or couldn't be used to fulfil the Uniserve contract.
Exactly that. There's a further point on ground 4, coming back to my Lord's question, as to whether we accept we couldn't, if the 15% requirement was in play, and High-Tech...
Just before we get to that,
Yes,
Mr. Cader's evidence in his witness statement is we had to keep or sell 15% of production for local market, and then High-Techs would retain about 15% of production Now, I can understand that that works if Uniserve's interpretation of the evidence is correct. That's to say, they have to reserve 15% of whatever they keep. But that doesn't really work, does it? If your interpretation is adopted, which is that they're free to deal with everything, and they simply have to provide 15% of whatever happens to be in their warehouse if the government asks for it.
I would
Because that's
say
not 15% of production, that's 15% of whatever their residual stock happens to be.
And it's perhaps, because the point wasn't being dealt with in that way, clumsy phrasing, but it was clarified in the oral evidence.
In the judge's question and the answer that came. Yeah. Okay,
Yes,
I understand that.
That's the point.
Yep.
So
Okay.
to the best of Mr. Hightex's, Mr. Cader's understanding, he could use those masks, as in fact happened in practice.
Right. Okay. Sorry, I interrupted you from showing us that. Anyway, you had enough.
Yes. So, can we turn up core bundle? We can put away the supplemental bundle. Core bundle, tab 10, page 101. We should have the table produced by Hightex, if I have my cross-referencing right. So, core bundle, tab 10, page 101. Does my lord see a table?
Although it's in
It's in Uniserve skeleton. It's in multiple places. Yes.
Tab 9.
Oh, tab 9, but yes.
I'm
yes.
sorry.
Page 101 is right. Yes.
I apologise. So we're dealing with two deliveries in respect of the 15% issue. Those we see greyed out, the 21st of June 2020 and the 5th of July 2020. So on the 22nd of June, the production report shows 5.6 million masks. There is a requirement to deliver 5 million masks pursuant to the revised delivery schedule. Now, if one takes off the 15%, there's a shortfall of just less than 200,000. But we saw at Judgment 336, I think it was Roman 3, the judge remarking that there is sometimes a lag in a production report. So what's recorded is not actually what's in the warehouse. The next day, on the 22nd of June, my lords will see that there are an additional 5.8 million masks recorded. It's nobody's case that Hightex is churning out 5.8 million masks in a day. It was Hightex's case. For your reference, if you need it, it's in the RFI Supplemental Bundle, tab 2, page 6, that its manufacturing capacity was 800,000 masks per day. The overwhelming likelihood from these figures is that there were millions more masks in the warehouse that were available that just hadn't been put onto the production report as of the 21st of June. It's overwhelmingly likely that the 200,000 shortfall, if the 15% applies, could have been met by masks that were in different parts of the warehouse. So in my submission, even if the 15% issue is right, it doesn't follow that on the 21st of June 2020, Hightex were not able to meet the 5 million commitment.
And you say is there a similar point in relation to the next delivery?
I'm going to make that point. Yeah, yes, indeed. 5th of July. Exactly that.
No, I actually was going to go to the next one.
Oh, sorry.
27th, 28th. There seems to be...
They're not challenged. There's only two challenges on the 15%, which is the 21st of June.
No, sorry.
I'm sorry.
Your answer is the challenge look, production reports lag.
Yes.
Now, I'm not aware of the judgment having gone into that issue in any detail. I think maybe there was just a single sentence, is that right, in the judgment to that effect?
You think so, yes.
Somewhere?
Yeah, well, 3363 by memory.
Okay. But you're saying that actually is a fair inference from the point you just made about the 21st and 22nd, that you
Yes.
can produce 5 million in a day. So I was just turning forward to the next point at which there is a jump in the number of stock on hand after sales.
Yes.
And that seems to be, curiously again, in fact, the 27th and the 28th. Now, I know you say there's no challenge around that, but there does seem to be a big jump in the recorded stock between the 27th and the 28th.
Yes, and there's a plateau between the 22nd and the 26th. In other words, there's no recording of masks being manufactured, but we know masks were manufactured.
Right. And then you are going to say, I don't know what you are going to say, but there's another jump at some point. But that's, you're saying that effectively these figures show that there are plateaus and then a jump.
Yes.
A plateau and a jump.
Yes.
And you say that's not credible because nobody suggests that they were virtually doing nothing and then producing vast quantities of masks in a day.
Yes.
And then doing nothing and then producing another vast quantity of masks in a day. You say it's more likely they were producing masks throughout, but somebody just wasn't keeping the production reports up to
Yes.
date and
Yes.
did it in bits.
Yes, I mean, there was a finite production capacity, and that's what we set out in our RFI of 800,000 a day.
But none of that was gone into in front of the judge, was it?
Yes, there was a great deal as to production reports and lags, and there was, I remember, distinctly cross-examination on that point, which I think is where we come out at, make sure I have my paragraph right, but 3363, where the judge says that there might have been a lag. I think that's the right paragraph. but it's, in my submission, it's evident from this table that Uniserve's produced that must be the case. Because where does that 5 million masks come from between the 22nd and the 21st? Can't have been produced overnight. So the second point of challenge on the 15% issue is the 5th of July. And I'm going to take you through a similar exercise to say why, if the production lag point is good, High-Tech's had on the 5th of July sufficient quantity of masks able to meet the requirement at that stage of 15 million, even if there was a 15% reservation requirement. I hope I have my maths right for this exercise. So, on the 5th of July, there was a requirement for 15 million. Less 15% we see in the right-hand column, that's 13.7 million. So there's a 1.3 million shortfall. On the 2nd of July, the production reports are showing 16.18 million masks. Same on the 3rd, and on the 4th a reduction because there'd been a local sale of 70-odd thousand masks. On the 5th, again, plateau, 6th, plateau, jump on the 7th. Now there's a jump on the 7th by 2.6 million masks. So if one prorates production over the 3rd to the 6th, so 2.6 million masks, over those 5 days, 3rd to the 7th, forgive me, that equates to 520,000 masks per day being produced. If we take those figures, 520,000 masks, for the preceding 3 days, so the 2nd, 3rd, 4th, or even the 3rd, 4th, and 5th, it's 1,560,000 masks against a shortfall of 1.3 million. So on that analysis, on the 5th of July, High-Tech's had a sufficient quantity to be able to supply Uniserve and to meet a 15% reservation if so required. My lords, those are my submission on ground 4. And then I move to 6 and 7, misrepresentation.
I don't think we need to hear from you on the misrepresentation issues, but we would like to understand a bit more about what the evidence was on the points you've just been addressing us on, to show that these figures can be explained on the basis that there was a lag in the production reports, and that in reality there was plenty, even after taking account of the 15%, to supply Uniserve. None of what you've been telling us about the arithmetic appears, as far as I know, in your respondent's notice or your skeleton, and we're not sure what the evidential basis for what, to us at any rate, is a new point is.
Yes.
I mean, you're right that the judge hints at this in 336, 3 and 4.
Yes.
The judgment. But I was slightly more perturbed when you sort of said there was lots of cross-examination and people went backwards and forwards over this and the evidence, etc.
I appreciate that's not in the bundle. I accept that. There was. I'm not going to speak to what it was. It's not before you. It'd be improper to do so. My recollection is there may be another passage or two in the judgment. If I'm given a few minutes, I'll see if I can locate that passage, or whether it's simply those two isolated subparagraphs to 336. May I have a few moments?
Yes. All right. Well, we'll rise for a few minutes. For
Thank you.
what should we do? About 5 minutes. That will...
5 minutes.
Yep. Very good.
Thanks.
What line?
I'm not in a rush. So we are looking like a finish today?
I think so.
I think so.
I think they want to. It's my
Yes, I do. Yeah. Just give me 1 minute. Yeah, we'll just write that. Just a second. What tab? Okay.
tab 1. Or tab 2.
Just let me find that reference tab. No. Yes, please. Yes.
Or Ryan able to.
Well, thank you for the time. Can I take you to the supplemental bundle, tab 21, page 346. This is Mr. Al-Grabili's trial witness statement. Paragraphs 15 and 16. However, there are instances, and sorry, forgive me, this is under the subheading above para 13, how High-Tech's counted the masks produced. However, there are instances where there are more completed boxes in the holding warehouse that have not been transferred to the main warehouse, but these will not be reflected in the system until they're transferred to the main warehouse. Exactly that point. There are goods, different warehouses, only when they made it to the main warehouse were they then recorded on the system. He goes on to say, consequently, in some instances, the reports reflected zero or low production, but this only means that the completed products have not been transferred to the main warehouse. We adopted this process due to the limited workforce available to High-Tech's. Consequently, we prioritised utilising the available workforce to manufacture masks and then update the number of masks in between. We ensured that only masks ready for delivery were transferred to the main warehouse to guarantee the minimum quantities required for orders were available. The masks in the holding warehouse were also ready on pallets. They just needed to be transferred to the main warehouse located on the ground floor. Mr. Cader also deals with this point.
So the production records show, therefore, the quantities in the main warehouse, albeit there may have been other goods produced in other places.
In the same factory, but just stored in a different room. And Mr. Al-Grabili says they're palletised, so they're already on pallets. We literally just needed to move them from one part of the warehouse to the next, and when they're in the next, they're recorded.
So if, on your case, delivery is having the goods available in the place from which they are to be collected,
yes.
Is that the main warehouse, or?
I can hear whispering, forgive me.
It's all in the same building.
It's all the same building, yes.
If we look actually, although you've taken the extract, paragraph 13 and 14 talk about small boxes being put into larger boxes and transferred within something called the High-Tech building. In fact, there's also a description of this process and the lag at paragraph 21.
Thank you, my lord. I've not got it. Yes.
And 22, in fact.
And was that was any of that cross-examined?
It was a year ago, my lord.
Right.
I don't want to misspeak.
Okay.
My memory plays tricks, so I'm not going to say exactly what happened in trial a year ago. There's been a few between then.
Thank you. That's helpful. Mr. Cader, I think you wanted to go.
Yes, so tab 22, where I got to in the short break was page 361, paras 37 to 39, which says, we think the same thing. Para 37, that the reports were the minimum that was available for the similar reasons. And that's as far as I've got to in the witness statement on point.
Right.
There are just two other points to come back to from my Lord's questioning. Section 37, I'm not going to duck the point. If we finish today, can I put in a note overnight? Obviously, I'll send it to my learned friend. If not, I'll deal with it in the morning. But I don't want to not deal with it. That wouldn't be right.
Yes, all right.
I'm very grateful. Estoppel and reliance. My Lord asked me, was there any evidence led on estoppel and reliance, or was it any of the pleadings? If one picks up the supplemental bundle, is it tab 2, page 5, which is Uniserve, Hitex's, forgive me, RFI response. And I'm looking at number 3. In circumstances where Uniserve has not informed Hitex or any of the claimants whether or not it intends to collect the goods, Hitex has kept 15 million units manufactured for supply to the Uniserve under the supply contract in storage to the Uniserve order. In order to mitigate its loss, Hitex ceased manufacture of further units on or about the 15th of July, thereby avoiding some of the variable costs of manufacture. So it was dealt with at the mitigation point, because that was the point that was in play. But what Hitex is saying is, because Uniserve were not coming to collect masks, they stopped producing. And that, again, that's as far as I've managed to get in response to reliance. Well, all those are my submissions.
We hear from Mr. Knight now, do we?
My Lord, yes.
Just take a moment to... My Lord, as you're aware, we now come to the appeal of Caramel and Mr. Popek. I'm going to refer to them more generally as Caramel. I don't think I ever need to refer to them separately, so Caramel is applicable equally. This is our appeal under the Commission contract, in which the judge urged whether it was a matter of either construction or the implication of terms to find the Commission was essentially payable under all shipments to be made under the supply contract, as varied by the revised schedule for delivery. I don't know whether you need me to go through the grounds again. Essentially, ground 1 is as a matter of construction, the judge was wrong. Grounds 2 and 3 are as matters of implication of terms, he was wrong. And ground 4, I accept in his failing to take into account sufficiently the supply contract. It informs 1, 2 and 3. It's not a separate.
Yes.
My Lord, save in respect of, we think, the exclusion clause of 10.6, despite the regular evolution of the law on the application of terms and construction of clauses, we don't think there is any real dispute over what the law is. It's merely a matter of application of that law, and the real focus is on necessity for the implication of terms.
Yes.
So, as a matter of construction, the court's task isn't really in dispute. The fundamental rule is that the court is to ascertain what a reasonable person with relevant background knowledge would understand the parties to have meant by the words used in the contract. It will be interpreted commercially, and a fair construction will match reasonable expectations of the parties to give effect to their objective intention. And that's to be ascertained from express language used and the surrounding factual matrix. We say, in the absence of express provision, that clause 4 operates as a precondition. As a matter of construction, given the expressed words in the factual matrix, it should be construed that it doesn't act as a precondition. Coming to the implication of terms on the law, if it's not possible to give effect to intention by the construction of words used, it's possible to imply terms if they're necessary or obvious. They'll often be the same, but not necessarily the same test. To a notionally reasonable person in the position of the parties, I've set out in both the skeleton argument and you as there in the authority, but I think it's sufficient dispute over what the criteria are to go to it now. But we can certainly investigate in due course if necessary. They're set out in new designs in the judgment of Lady Justice Carr, as she then was.
Manchester, just a second. At times, your voice is just dropping a bit
Oh, I'm
too
sorry.
low for me.
It may be
Perhaps
the
because I'm
distance between us. My lord. I think it happened the other way round.
Yes.
And to the extent that there are any other references in the skeleton arguments to supplement the EU decision, or really it comes from Marx's Spencer case, they're not controversial. As I say, it's really a matter of necessity. So we say if clause 4 is a precondition, or alternatively put as a condition precedent, it is necessary or obvious that a term must be implied with respect to Uniserve procuring delivery to the UK. Put simply, to expand on it, we say that express words in surrounding factual matrix make it clear that the common intention of the parties was A, that commission would be payable on all goods supplied under the contract.
What do you mean by supplied?
Well, we say, I was going to say, and it's dependent on Hitex's obligation. It doesn't, Uniserve was obliged to collect.
Sorry, you say it. Sorry, when you say commission is payable if goods are supplied under the contract.
If they're made available in accordance with the contract.
So,
ready for collection.
So, if at any time there have been produced enough masks to fulfill a schedule, irrespective of whether they've been separated in the warehouse, irrespective of whether anybody's been to collect them, commission is at that point payable.
We can come to that. There is a clause which we say deals with any defect in the obligations of Hitex to fulfill its own obligations. So we say if Hitex has fulfilled its obligations.
Okay, so the only reason I was getting into this is because you used the word supply.
I did. Okay, it would be better if I said if Hitex has fulfilled all its obligations, because I don't want to repeat the arguments my learned friend has been making. We say it applies to all shipments to be made under the contract.
So on all shipments which either were in fact made, or which should have been.
We'll have a look at it because commission is not payable if Uniserve doesn't have to pay Hitex. So we say actually on a proper construction it's payable on all shipments. And then we say if it's not possible to
And you said, and at some point you'll need to deal with the timing point. I mean, obviously you've got to deal with the argument, but I would like to understand very precisely when you say a binding legal obligation to make a payment came into being. That is a binding legal obligation between the payer of the commission and the receiver of the commission.
So to put it in reverse, can it really have been the parties common intention, objective common intention, that the Commission would not fall due if Uniserve decided to deal with the goods otherwise than by collection and procurement of their delivery to shipment to the UK. Because that is the implication of what is said against us. My Lords, if I could take you to the Commission contract.
I mean, I can understand that if Uniserve decide on this ex-works contract that they're not going to take the goods to the UK, but going to take them somewhere else and sell them,
Yes.
that you would say that commission should still be payable. Yes. But you say that also, do you, in respect of goods which are simply not collected in breach of contract?
Yes.
Where it's not therefore commission on the price, but it's damages for non-acceptance, which effectively ought to include damages for non-payment of commission.
Yes.
Is that how it works?
Yes. And I think we would say that the obligation of payment, well, no, it does depend. The timing of payment is the date of shipment.
Well, these are goods which are not shipped.
Absolutely. It's the proposed date.
Which are not
It's
accepted.
the date that shipment was supposed to happen.
Yes.
Because it's by reference to the schedule.
And by shipment, you mean?
Well, by shipment, we'll see the definition in the contract.
And do you say that the answer you've just given, my lord, follows as a matter of interpretation of the contract, or as a matter of implication of terms? The example being collection of goods ex works, and then taken by Uniserve somewhere else.
A matter of construction of clause 3 in its contract,
Right.
which founds the general obligation, the primary obligation to pay for shipment.
So no implied terms necessary.
We say first no implied term is necessary, but if you can't come to that conclusion, on that element, whether they're due on shipments, we say first that it will be due in any event. But if we're wrong on that, then Uniserve is obliged, there is an implied term, Uniserve is obliged to collect in order to fulfil its duty to procure shipment to the UK. Well, I'm about to take you to the commission contract itself. It's at page 432 of the core bundle, the final tab. I'm going to look at the factual matrix first, but much of it is reflected in the contract itself. So as to the factual matrix, we say the important elements are that it was wholly interrelated to the supply contract. In fact, as we characterised it before, it was parasitic on the supply contract. It was directly linked to supplies to be made under that contract. The second is that Caramel's principal consideration is past consideration. The introduction has already been effected, and that's what it's being rewarded for. So the commission is a reward, it's not an inducement or enticement to obtain further contracts. Number 3. Number 4, Caramel was the agent of the seller, ITEX, not of Uniserve. Fifth, the supply contract was a contract for delivery and collection ex works. But as my lord noted yesterday, the supply contract does not require delivery to the UK. Uniserve is free to do what it wants with the goods. I then want to look briefly at the factual matrix that...
So you said supply contract does not require delivery to...
It doesn't mention any obligation of Uniserve having to bring them to the UK.
That's what I thought you meant. Sorry. You dropped your voice, and
Sorry.
Even here, I couldn't
I'm sorry.
understand whether you'd said UK or Uniserve. So the supply contract doesn't require delivery to the UK,
Yes.
but it does require delivery to Uniserve. The supply contract.
Well, it doesn't require Uniserve to ship goods
Correct.
to the UK.
But the supply contract does envisage delivery to Uniserve.
Yes.
Yes. Okay.
Yes. My learned friends have noted a number of additional factors which we say are relevant in their scope of argument at 444.35. I don't think we need to take it, I'll say what they are. Uniserve is first and foremost a logistics company. We don't think that takes matters very far because at this time, the material time, they had become a supplier of PPE. They say that Uniserve began procuring PPE during the pandemic period because it had seen an opportunity to supply based on experience and connections. We say much the same for that. It's now a player in the market.
The key point that's made, I think, in relation to that is that Uniserve, they say Uniserve became a supplier of masks in the UK, and therefore when you say it became a player in the market, they
Yes.
say it's a player in the UK market.
And that certainly is what everyone thought. That we say that was the common intention, the basic common intention of this contract was that all the goods would come to the UK. It wasn't binding, well, it's not a binding obligation under the supply contract, but it was certainly the common intention under this contract.
But you were not introducing them to a purchaser in the United Kingdom, you were introducing them to a supplier in Jordan.
Yes. Yes. And we agree that these are relevant to the factual matrix, but the fact is by now they had become, it's a complex market, people are trying to get masks everywhere, governments are fighting over them, people are trying to supply them here and there. The court found that there was a market at the time. The next part of the factual matrix that my learned friends rely on is that the parties knew there was only ever one end customer, the DHSC in the UK. But we say that overstates the position. The parties absolutely anticipated and expected all those masks to be supplied to the Department of Health. But Caramel certainly couldn't have known this to be the case.
But at the time this contract was entered into in April, as far as the UK market was concerned, you couldn't get hold of masks for love nor money.
Absolutely.
And the NHS, in fact, had a monopoly on any source of supply of face masks.
Yes, yes. I mean, you're not suggesting there was
A market for these face masks in the UK in April to anybody other than the DHSC.
No. Everyone thought that was where they were going.
Yeah, I mean, that's
They didn't know it was where they were going because maybe Uniserve had other plans. We didn't know. But everything they had said to us suggested that that was what was going to happen. We know there's a frantic market. We know there's no contractual bar to them shipping things, so it's possible. Nobody thought it was going to happen.
Yeah.
And certainly neither Caramel didn't know the terms of any contract with the NHS. They didn't know whether Uniserve was going to make a profit. They didn't know how many they had to supply.
I'm just struggling still to understand why you say, and we haven't looked at it, how exactly how it's put, that it was anticipated by both sides that the only customer in the UK would be DH, Department of Health and Social Care, whatever it was called at the time, DHSC. Why do you say that overstates the position? I mean, is it just that you didn't know for sure what the terms of that arrangement was? But
we didn't know that they would. We fully expected that is what they were going to do.
So it's a very limited overstatement.
Yeah, I accept.
That's what I thought. Okay.
What I'm saying slightly overstates the position because we didn't know that. And this was all of these simply go towards the same common intention. We say is the common intention under the commission contract was that all the goods would come to the UK. So if we could turn to the commission contract itself. Page 432, again, of the core bundle. So as I said, at 1.1 we see that the principal consideration of Caramel has already occurred. They have introduced Uniserve to Hightex. 1.2, Uniserve has entered into a supply agreement with Hightex, copy of which has been provided. Pursuant to the terms of the supply agreement, the supplier has agreed to supply Uniserve those masks. It's implicit in that Uniserve has agreed to purchase. It's not an option that it has agreed to purchase them. At a price of 30 cents, and in accordance with the following shipment schedule. I'll be coming back to the implications of that shortly. Paragraph 2 is essentially a series of warranties that have been given. And then the critical clauses come at 3 and 4. So the first is commission. 3.1, in consideration of the introduction. The parties hereby agree that Uniserve shall pay to the introducer a commission which shall be calculated for each shipment on the following basis. The shipments have been defined on the previous page as shipments under the following schedule, but they are the ones referred to in the supply agreement. It's essentially saying shipments, we say, made under the supply agreement, and I'll be coming back to this shortly.
I think, and I say this with great hesitation, but I've just
That is an
checked it on
appropriate
my
time.
calculator, that the worked example arithmetic is wrong. Because 0.3 times 5 million is not 1.25.
No, we've got to apply the exchange rate.
Divided by 1.2.
Oh, I see. I hadn't seen that. Okay, good. Oh, that's a relief.
It certainly is. In fact, it wasn't.
The exchange rate is quite important, though, isn't it? Because it looks as though the exchange rate is calculated on the date that the goods arrive in the United Kingdom.
Yes.
So you can't
Well,
you can't do the
But that's-
calculation. Can you on the strict wording? You could not calculate the commission before the goods arrived to the United Kingdom.
no in my submission because of B above. It's equal to the sterling equivalent of the total amounts paid by Uniserve to the supplier for that shipment.
I mean,
So it depends on what they're paying. It doesn't actually depend on 4.
as I understand it, where you're going to go is you're going to say, look, the schedule, which is the basis of the definition of shipment, is the schedule of making available for collection X works, which happens in Jordan. Shipment, therefore, happens in Jordan. Therefore, the commission is payable and calculated by reference to events which occur solely in Jordan, end of. And the invoicing and payment mechanisms, which are by reference to what happens in the UK, are just invoicing and payment, but the core obligation set out in commission in paragraph 3 is solely referable to shipment, which is a purely Jordanian thing under the supply agreement.
My lord, you're several pages ahead of me in my note.
Right, but that's where you
Essentially, that's what we're saying.
Right.
That's probably a convenient time.
Okay, 5+2.
What rise is able to